Good morning, this is your Kelso Report for Monday, March 25th. I'm your host, Clark Kelso. Good to be back from spring break. Well, last week while I was gone, the Supreme Court issued 4 opinions. The first dealing with the first sale doctrine under the Copyright Act. The second dealing with federal jurisdictions under the Class Action Fairness Act. Third, dealing with the Clean Water Act and storm water runoff from logging roads. And then finally, a case dealing with a technical issue of preemption under the Medicaid program. Let's get started with copyright. One of the important limits placed on the monopoly rights granted to a copyright owner is that a person who lawfully owns a particular copy of the work is entitled to sell or otherwise dispose of that copy. In essence, the copyright owner gets the first sale of the work, but subsequent owners of that copy may themselves dispose of the work as they wish. The copyright law has a different provision which is intended to protect copyright owners from unauthorized importations of copies of the work from foreign countries into the United States. Now, according to the importation provision, importation into the United States without the authority of the owner of the copyright is an infringement. The court had to reconcile these two apparently conflicting provisions in Kurtzsang versus John Wiley and Sons, where the court held that the first sale doctrine applies even though the work was manufactured and first lawfully sold abroad. The purchaser of that work is therefore perfectly free to bring the work into the United States and resell it here. Next, turn to a case involving civil procedure and class action law. The Class Action Fairness Act of 2005 gives federal district courts original jurisdiction over class actions in which, among other things, the matter in controversy exceeds $5 million in sum or value. The Act also provides that individual class member claims must be aggregated for purposes of the Act. In Standard Fire v. Knowles, plaintiffs' counsel tried to do an end run around the Act by stipulating before certification of the class that the class would not seek more than $5 million in damages. Clearly wanted to stay in state court. Well, counsel conceded that absent the stipulation, the damages would have exceeded $5 million. Given this concession, the Supreme Court unanimously held that this type of stipulation does not defeat the jurisdiction created by the Act. In particular, the court noted that prior to certification, the plaintiff cannot enter into a binding stipulation that would bind non-absent class members. So while at best the stipulation applied to the named plaintiffs, it could not apply to future class members. And since the amount in controversy was clearly above $5 million, removal to the federal court was appropriate. Next, on a case involving the Clean Water Act. The Clean Water Act requires permits when storm water runoff is associated with industrial activity. Stormwater runoff that is not associated with industrial activity, of course, does not require a permit. In Decker v. Northwest Environmental Defense Center, the Supreme Court faced the question of whether permits were required with respect to channeled stormwater runoff from logging roads that ultimately discharged in the navigable waters. You build a little channel next to the logging road, and you're going to have runoff going down that channel. Well, the EPA interpreted its rules as not requiring a permit unless the runoff was directly related to manufacturing, processing, or raw material storage areas at an industrial plant. Stormwater discharges from logging roads did not fall within this definition, since they were not directly related to discharges at an industrial plant, so the EPA determined that no permit was required. The Supreme Court held that EPA's determination was a reasonable interpretation of its own regulation and was therefore entitled to deference under Auer v. Robbins. The court upheld the EPA's determination. Finally, we have a technical preemption case involving health care. Of course, hundreds of billions of dollars flow between the federal government, state government, and providers who provide health care services to Medicaid beneficiaries. Well, when the medical expenses are made necessary by the tortious activity of a third party, and the Medicaid beneficiary recovers a tort judgment or settlement, there can be a little bit of a food fight over those proceeds. Federal law requires an assignment to the state of the right to recover that portion of a settlement that represents payments for medical care. However, federal law also prohibits states from attaching a lien on the property of a Medicaid beneficiary to recover benefits paid by the state on the beneficiary's behalf. Construing these two provisions together, the federal anti-lien provision preempts a state's effort to take any portion of a Medicaid beneficiary's tort judgment or settlement that is not designated as payments for medical care. They get the payments for medical care, but nothing else. Well, in Wass versus EMA, North Carolina had enacted a statute requiring that up to 1/3 of any damage recovered by a beneficiary for a tortious injury be paid to the state to reimburse it for payments it made for medical treatment on account of the injury. The Supreme Court held that this statute was preempted by the federal anti-lien provision because it created an irrebuttable presumption that 1/3 of a tort recovery represented the amount of state payments for medical care. Since that presumption is contrary to the limitations imposed by the federal statute, it is preempted. As the court noted, the North Carolina statutes set forth no process for determining what portion of a beneficiary's tort recovery is attributable to medical expenses. And that is contrary to the methodology required by the applicable federal law. So the North Carolina statute is preempted. Well, that's it for today's Kelso Report. Have a great day in the law.